everyone. I'm really excited to be here this evening and to have as a guest Rowan Dorin. Kaspar Ehlers and I will give a short introduction to his biography and his work, and then he will delight us with a very interesting presentation. I'm sure that the topic he will discuss today is very important for many of us, as we are working more on an early modern period or contemporary period, but using the same or a similar approach. So I would like to present to you Rowan Dorin. It is an associate professor in history and served as core faculty at the 12th Center for Jurist Studies at Stanford. He pursued his undergraduate studies at Harvard College, followed by a Master of Philosophy in Medieval study from the University of Cambridge in 2009, and then a PhD from Harvard University in 2015. His research primarily focused on the history of Western Europe and the Mediterranean during the High and Late Middle Ages. He is particularly interested in the dynamic relationship between law and society, examining how legal norms intersect with social practices. Additionally, he delves into the history of economic life and thought, particularly medieval discussions surrounding usury and money lending. And another aspect of his research explores the intricate network of trade, migration, and intellectual exchange in the medieval Mediterranean. His first book, No Return, Jewish Christian Users and the Spread of Mass Expulsion in Medieval Europe, published last year by Princeton University Press, investigates the phenomenon of mass expulsion in later Middle Ages through the lens of the banishment of Jewish and Christian moneylenders. Currently, he is engaged in a second project that explores the adaptation, reinterpretation, and resistance of medieval canon law within local context during the 13th and 14th centuries. This project builds upon the development of Corpus Synodalium, a comprehensive database of late medieval local ecclesiastical legislation, which has been working on since 2016 with some collaborators worldwide. This project is also connected to a digital atlas of dioceses and ecclesiastical provinces in the late medieval Europe, which is also one of the reasons because Rowan is here today. Tomorrow we will have a very interesting meeting and workshop. We are actually merging two projects dedicated to dioceses in the Middle Ages and early modern and contemporary period, so I'm really happy that we will have also this opportunity for discussing. Now I'll let the floor to Kaspar Ehlers. He's a senior researcher at the Institute and the coordinator of the research field Knowledge of Normativity from the sphere of the religious of our department. And he will give us some words about the work.
About the book, yes, thank you very much for your attention. I have the honor to present the book of our guest speaker tonight. The title was already mentioned by Benedetta, No Return, Jews, Christians, Usurers, and the Spread of Mass Expulsion in Medieval Europe. I don't have a hard copy, I just use my electronic device, and I would like to give you some impressions of this very interesting. Yes. This is a book, an impressive volume, and I say it in front. It's worth reading because the most interest that seems to me to what have guided Rowan's book was the connection about the topics Benedetta also just mentioned: migration, merchants, intercultural, interreligious conflicts or intertrade, and so he will take us on an interesting ride into the higher medieval times. The most topic are two things: the expulsion of the Jewish people in England and as well as in France. But instead of telling a story from year to year, you can find this in Annex 1. He tries to point out the intellectual as well religious as from the canon law inspired discussion, how the reasons were found and in a way founded on ecclesiastical norms, or meaning arguments coming from the Holy Bible and from the canon law, as well as from the antique Roman law. And I don't want to read a lot of quotations, but it's fascinating. So to make a long thing very short, how he can show, like in different situations, different people gave different answers to the same question. Starting with money exchange and going over to usury, and what he makes in several points of his book very clear is that this is not only a problem which were the Jews confronted, it's a problem of practice as well from Christians as from Jewish people. And in the first years of or first centuries up to the High Middle Ages, say the 11th, 12th century, the money exchange business or giving credits was mostly done by Italian and South French merchants. And the Jews were not so much involved in this. And since the ruling was that one has left to leave the Jews do what they want to do, what their culture is, what their religion is giving them, and don't disturb them. And then, at a specific point, the wind changed, and the Jewish communities are coming into the focus of clerics as well as of lay people. And the interesting path he describes is how arguments coming first from the Roman law and the Bible, how to deal with people which were lending money and making profit with it, and if they should be treated like lepers, prostitutes, and other outsiders of the Christian society. And then these arguments were put into account for arguing against Jewish communities. First, if I got it right in remembrance, first there were only single persons in focus, and then the focus broadened and the entire Jewish communities were, so to speak, under attack. But that was not a linear process, right? It was a process of discussion. And I found very interesting his explanations on how, for example, on the universities of Paris, these things were discussed. He provided a lot of sources, texts, and I have to go for your knowledge of all these sources and how to deal with them, how to present them in a not too easy way, but for someone who is in the matter more or less. It's fun reading it, really. It's really interesting. I would like I could write as well as him. To explain these intellectual dialogues between the people at the university in Paris and with the popes, and how the popes changed and which influence the part of the Crusades has. For example, Innocent IV, and how these things change between the third, the fourth, and the fifth Lateran concile, and so on. And then in those main parts, he follows argumentation as well as the happenings in France as well as in England. And then he closes with, I think, very sharp remarks on which you can find always here and there in the text, where he put the finger on an open wound in recent historiography and intellectual history, where he says, or where he argues that since the 19th century, no one has really touched or recognized this problem, what I just tried to point out, this problem, how the Jews were put into the focus of the discussion, and how the results of this discussion led to the expulsion. And he discusses the term of the expulsion on many aspects, so that in the end one can say, yes, this seems to be an appropriate way to deal with this very complex problem. It's two countries, two medieval countries. It's a huge intellectual space. It's a timeline from the 11th century and until the 15th. And he has also included, as I just said, the research in the 19th century. He spots where in recent times the ways or the doors would be half open or ajar, where one has to go through, like he did, to open this horizon. And when you want to follow or interested only in chronological approach, you can use his appendices, where this is in respect of the timeline and in respect of the sources. It's in a shortly compressed way also readable, and you can jump between these annexes and the text. So everyone who is interested in this should read it. Thank you very much.
Thank you, Kaspar. So thank you, Rowan. The floor is yours. Afterwards, we will have a discussion, so I invite you to think about questions or comments. And if you want to ask something, we will invite you to come here near the table, because the microphone is here, so it's much better for the participants that are following the lecture from the internet, which I welcome also, that you ask your question from here.
Thank you so much. So let me begin my talk this evening by expressing my thanks first to Benedetta Albani for this very, very kind invitation to be here this evening, as well as for tomorrow's workshop, to Anna for coordinating everything so efficiently, to Professor Ehlers for that very kind and thoughtful and gracious discussion of my book, and of course Professor Duve, who has made this institute such an extraordinary place to ask the sorts of questions that I'll be talking about today, and why I'm so excited to be sharing my research here with you. Zweitens möchte ich mich beim deutschsprachigen Publikum entschuldigen. Da zwei meiner Großeltern Deutsch als Muttersprache hatten, befürchte ich, dass sie ziemlich enttäuscht wären, wenn ich meinen Vortrag auf Englisch halte. Aber wenn Sie meinen deutschen Akzent hören würden, wären Sie wahrscheinlich noch enttäuschter. Auf Englisch muss es also so sein. So much of my talk this evening echoes, and indeed in many respects builds on, work done here at the Institute on early modern law, legal cultures, regimes of normativity more generally. From the recent volume on knowledge without pragmatici, to Manuela Bragagnolo's wonderful recent collection of essays on the manual confessors of Martin of Azpilcueta, and much more beyond. But since most of this research has focused on the early modern period, I hope that it might be illuminating for members of this intellectual community to reflect with me this evening on the ways that some themes of common interest played out in the preceding centuries. And for those of you who reckon yourselves as medievalists, I hope that my talk will highlight certain aspects of medieval law and some of the patterns through which historical regimes of normativity are constructed, that we often take for granted, but which perhaps deserve more systematic interrogation. Now, I'll set the scene for my talk with an example drawn from the nearby Archdiocese of Mainz. In 1274, Archbishop Werner von Epstein returned from the Second Council of Lyon. And I'm showing you here a nice manuscript illustration of Pope Gregory X, surrounded by the conciliar fathers, issuing the constitutions that would result from the Council of Lyon in 1274. Now, upon his return from Lyon, the Archbishop of Mainz convoked a synod, a diocesan synod, in which he issued some synodal statutes. Now, of these, of the 37 resulting decrees in these statutes, 16 of them relayed in some fashion the conciliar constitutions that had been recently issued at Lyon. And Canon 13, in particular, barred anyone from allowing foreign manifest usurers, or even manifest usurers who were native to their lands, to dwell within the diocese. And so here you see the Latin, more or less saying that as it was declared or ordered or warned in the Council of Lyon, that foreigners or even those who are native to their lands shall not allow manifest usurers to dwell therein. Now, what makes this text interesting was that although this is what he declared, the Council of Lyon had declared, this isn't quite true. Because in fact, the actual text of the Council of Lyon declared that it was to be foreigners and others who were not native to their lands who were to be barred from residing there if they are manifest usurers. And yet we see in the Mainz text that instead of having et alios non oriundos, we have alienigenas vel etiam oriundos de terris et sorum, a rather significant broadening of the decree that is found in both of the surviving manuscript copies of the statutes. One at the Oxford Bodleian Library and one now in Leipzig. Now, perhaps this was simply a deliberate case of broadening. The Archbishop perhaps felt that the Lyon definition had been too narrow. But at least one copy of the conciliar canons of Lyon, which was copied sometime in late 13th century and belonged to the library of St. Martin's Cathedral in Mainz, had a scribal error, in which it too was missing a non, reproducing the Lyon text but reading alienigenas aut alios etiam oriundos et terris ipsorum. So this manuscript now in the Vatican, which was held at the Cathedral of Mainz, and may indeed have been the manuscript from which the Archbishop's drafters were working, professed to be a copy of the Lyonese conciliar constitutions, but with an important textual change that broadened its meaning. And thus, assuming that it was indeed the redactor using this mistaken manuscript, defective manuscript, who then copied out synodal statutes, we see how scribal error led to substantive legal change. Something we find perhaps too little discussion of among later medievalists, in contrast of scholars of ancient law and of early medieval law who are ever attentive to the implications of discordant textual traditions. For those who work on the High and Late Middle Ages, such scribal errors, such textual variants are too often relegated to the notes of critical editions, hidden perhaps behind the mirage of the systematization of legal knowledge during the 13th century and later. And I would put it to you that there are so many interesting questions to be pursued if one were to turn these footnotes into the starting point of investigation and wonder about the substantive implications of scribal variations and scribal errors. But lest I digress too far from my talk this evening, I want to emphasize again a key point about the Mainz synodal statute, which is that the rhetoric here claimed to be transmitting the text of the conciliar decree, cum notunensi concilio sic sancitum. So this wasn't simply sort of passing on norms, but it actually claimed to be producing the authoritative text, or at least transmitting its authoritative provisions. Now let me give you another example, this time from the Archdiocese of Cologne. Synodal statutes issued by Archbishop Siegfried von Westerburg sometime around 1280. And here, he decided to convey another constitution also issued at the Council of Lyon, again by Pope Gregory X. And again, as you see in this text, he notes that we hope that it'll be observed the constitution, quae est talis, basically, which is as follows. Then he proceeds to spell out quam usurae manifesti Deus usus, and he spells out verbatim the entire text of the new conciliar constitution into the Cologne Synodal Statutes. And indeed, as we can see in the wonderful new recent edition by Hans Wotter of the Synodal Statutes of Cologne, in which, in classic German form, we have the small type for the borrowed text. Indeed, it goes on almost word for word, perfectly following the canon law all the way through, a verbatim transcription. But there is no indication in the text of the medieval statute, nor in the layout or the notes to the new edition, that the final line, the final clause of the conciliar constitution is missing. Testamenta quoque manifestorum usurarium, aliter facta non valeant, sed sint edita ipso iure. A clause that declared null and void any testament made by a manifest usurer. And this omission, again, is found in the dozen surviving manuscripts of the Synodal Statute, so we can't chalk it up, at least, to being a simple error. If it was a simple error at the beginning, it's one that replicated itself in every single copy of the statutes. It disseminated itself within the Diocese of Cologne. So was this an inadvertent slip by the redactor, the result of a faulty exemplar? I'm tempted to see it as a deliberate choice, given that the provision itself was bold and controversial, and given that the majority of other 13th and 14th century bishops who issued statutes that transmitted part of this new conciliar decree also omitted this final clause. Now, the cases of Mainz and Cologne are somewhat exceptional. We have powerful and wealthy archbishops with well-staffed curias, issuing statutes immediately following a general council, and claiming to transmit new conciliar norms, while silently, perhaps inadvertently, modifying their substance in important ways. Now, this raises a thorny jurisprudential question. What exactly is the juridical force of a statute promulgated by an archbishop that does not, in fact, reproduce the higher law that it claims to be reproducing? But rather than go down that particular jurisprudential rabbit hole, what I want to focus on this evening is, as my title indicates, what these examples and others suggest about legal diffusion and normative instability in medieval Europe. My interest in this theme emerged out of my research into the conciliar decree Usurarum Voraginem, passed at 1274 at the Council of Lyon. Though when I began, I was mainly interested in economic and social history, and I hardly expected that legal history would become the focus of my inquiry. But I came to be fascinated by the gap between the Church's authoritative statements, as formulated, for example, in conciliar decrees and compilations of canon law, versus more local understandings, as attested, for instance, in student notebooks, synodal statutes, sermons, songs, and so forth. This is hardly a novel insight for those who specialize in the social history of the late medieval church. And yet historians of medieval economic life regularly write as if merchants, or even their confessors, were familiar with the ins and outs of the church's rather complex teachings on usury. And if one reads a lot of recent work in the history of Jewish-Christian relations, it's again striking how readily scholars assume that people on the ground actually knew what the Fourth Lateran Council had ordered, or it was spelled out in the various papal decretals governing the appropriate interactions between Christians and Jews. Even specialists in medieval canon law, who have stressed the uneven transmission of the acts of church councils, have largely limited their studies to learned compilations, without looking at the transformations of formal sources of law, as they were taken up into other genres, or as they reached less learned audiences. So let me start now by putting the text of this decree on the screen, since it will matter for the variations I'm going to discuss thereafter. And to give you a moment so you have a break from listening to me, I'll give you a minute to read it on your own, especially since it is a legal statute, and although this audience is well used to reading legal statutes, the language is somewhat complicated. And for those of you more comfortable with Latin and English, I apologize for giving you the translation here. So I'll give you a minute to read it. In short, this conciliar decree, an abyss of usury, usurpam voraginem, ordered all secular and ecclesiastical rulers in Christendom to expel from their lands within 3 months any foreigners who were engaging in usury. It also forbade anyone from renting houses to such usurers. Ecclesiastical transgressors faced serious automatic sanctions, while lay transgressors were to be sanctioned by their bishops. The decree's demands marked a milestone. While previous medieval expulsion orders had concerned cities, duchies, or kingdoms, the decree's provisions theoretically embraced all of Latin Christendom. Not since the age of Justinian had a European authority issued such a sweeping and categorical call from the collective banishment of wrongdoers. And despite its sweeping ambitions, the decree was hardly a masterpiece of legal draftsmanship, due in part to 2 rounds of hasty revisions, probably made during the council itself, or immediately afterwards. In the initial version, the housing ban and expulsion order had applied to all manifest usurers. Over the course of the 2 revisions, which we can see the traces here, these penalties were limited to foreign manifest usurers, though the drafters didn't exactly specify who counted as a foreigner, which caused lots of headaches for candidates and ultimately provided a loophole for many professional moneylenders trying to evade the decree's sanctions. But that's another story. The easiest way to disseminate knowledge of the council's new decrees was obviously for the council's participants to take copies home with them. And many did just that. But some left early, or else brought home copies of draft versions without realizing or worrying that further changes might be made. And this seems to have happened in the Diocese of Passau. The Archbishop of Salzburg held a provincial council on October 1274, several weeks before the official promulgation of the final text of the council's decrees, where he ordered all of his suffragans to repeatedly publish the new Leonese decrees within their diocese. And it seems that what ended up circulating in Passau was based on a draft version of the decree, such that anyone learning about the decree within the diocese in these early days wouldn't have known that its penalties were restricted to foreigners, rather than all manifest usurers. Similar, in fact, what happened in Mainz, though in this case due to someone leaving with a draft copy of the decrees rather than an effective one. Now, as you all know, diocesan statutes and provincial canons were one way that knowledge of church doctrine might be transmitted to the faithful in the later Middle Ages. And I've now looked at just about every surviving instance of these statutes, about 2,300 of them in total, to see when and how the language and provisions of usurpam voraginem appear from 1274 until the end of the 15th century. And just to give you a sense of their number and distribution, here's a map showing the distribution of all diocesan episcopal statutes for the 13th to the 15th centuries. And then here's one showing the provincial canons for the same period. But here is the map of the dioceses and provinces that actually incorporated the expulsion provision into their statutes. A rather more restrained geography than the full set of statutes. And indeed, in light of the relative infrequency, the textual instability, and the uneven geographic distribution of references to the decree, one might even go so far as to argue that local episcopal legislation did as much to suppress or distort this general law of the Church as it did to reinforce and supplement it. But although provincial councils and synods were an important means of disseminating ecclesiastical norms in the later Middle Ages, there were lots of other important genres for popularization and dissemination of church teachings too. So I went looking for references to the decree in just about every genre that I could think of, down to the end of the 15th century. Some of these are consciously legal in nature, such as epitomizations of canon law. I've also looked at just about every extant late medieval pastoral handbook and penitential treatise, some 3 dozen in all, as well as a dozen treatises on usury, avarice, and mercantile ethics. Sermons were, of course, another important vehicle for disseminating norms, but they're a challenging genre to deal with, not least because there are at least 100,000 extant Latin sermons from the later Middle Ages, and untold more in the vernacular, and needless to say, I did not read them all. So here I tried hunting for references to the decree in the most likely places that I could think of. And I ended up examining about 130 sermons by 40 late medieval preachers that took as their thema either the cleansing of the temple, a staple of Lenten sermon cycles, or the Deuteronomic or gospel prohibitions on usury, Luke's account of Jesus expelling demons, or Paul's reference in Galatians to the expulsion of Hagar. Unsurprisingly, with the exception of the epitomization of canon law and the manuals for confessors, most of these sources, statutes, pastoralia of various sorts, treatises, and sermons, made no reference to the decree. In some instances, however, the silences are telling. Here you can see the attested activities of foreign Christian moneylenders mapped against the jurisdictions that issued statutes, ecclesiastical statutes, insisting on their expulsion. And as you can see, some bishops in the Low Countries responded to the density of moneylending activity by invoking the decree, but the bishops in most of Burgundy and Savoy stayed silent, which raises the question of whether local secular authorities had any idea that they were bound by church law to expel such usurers. It also underscores how reluctant most prelates were to enforce the church's teachings on usury, which is something that really ought to be stressed more often, but that too is a topic for another talk. For nearly all of these genres, including nearly all episcopal statutes, aside from the very, very few that simply recopied the decree verbatim, the process of dissemination necessarily involves shortening or simplification, the omission of words, of phrases, of provisions, rewording of technical language to more everyday terms. There's an implicit editorial process, of course, in thinking how to simplify for non-professional audiences, for less learned audiences. But this process, these selection criteria, are rarely given sustained attention by legal historians, with the honorable exception of some researchers affiliated with this institute. It's certainly acknowledged, but almost never analyzed. And yet, as we know, shortening and simplification are not neutral processes. The choices made are revealing. Even those texts that do mention the decree in some fashion often omitted any mention of its expulsion provision, transmitting only its housing ban, or sometimes just its redolent opening words, its incipit, without any substantive provisions at all. Others weakened its enforcement provisions by omitting any reference to the laity, or dropped the enforcement clauses altogether. The Saint Bishop Antoninus of Florence, for instance, referenced only the decree's housing ban in his Summa Theologica, completed in 1454. As for secular rulers who rented houses to usurers or allowed them to dwell in their lands, Antoninus said nothing about the need for expulsion, ordering them merely to make restitution of whatever revenues they had levied from the usurers, a threat to their strong boxes perhaps, but not to their souls. Similarly, a 15th century German manuscript containing summaries and abbreviations of canons noted both Usurorum Viraginum's reiteration of the Lateran penalties and its rental ban, but said nothing about its broader expulsion order. As for the decree's targets, whether in statutes, confessional summas, or sermons, we often find the restriction to foreigners being dropped altogether. In the popular Summa Confessorum that the Dominican Johannes von Freiburg completed around 1300, for instance, the extended quotation from Usurorum Viraginum duly cited the decree's restriction to foreign usurers. But the German vernacular translation produced roughly a century later simply ordered the expulsion of usurers, vucre. Here, therefore, the simultaneous process of translation and abbreviation led to the omission of the restriction to foreign usurers that the base text had been careful to maintain. Meanwhile, diocesan statutes in Basel and Lucca followed the example of the Mainz statute in making the decree applicable to both foreign and local usurers, but again, mentioning only housing rather than expulsion. The early 14th century synodal statutes of Carcassonne banned clerics from renting houses to foreign usurers on pain of excommunication, while also ordering them to expel all manifest usurers from the jurisdictions, and the same distinction was taken up in later statutes from nearby dioceses. Now, it's quite possible that this resulted from an inattentive reading of the decree, or perhaps even from a faulty exemplar. But even if this was an instance of editorial sloppiness on the part of the drafters, it's notable that none of the subsequent redactions saw fit to correct it. Then there's the case of the medical doctor in early 14th century Padua, with a taste for foreign literature, who copied down a French vernacular versification of the council's decrees. It was a summary of the decree stated simply that usurers were to be treated like heretics, pour bourg retenu, whatever that was supposed to mean. So if we turn to the provisions of the decree, we find in some instances that justice incipit was invoked and nothing else. Secular authorities might be dropped as objects of requirements. The language of foreignness might be altered or changed, or dropped altogether. Whether 3 months or a different time frame was also up for changes depending on who is redacting versions and transmitting this. And sometimes the expulsion provision disappeared entirely. Renting houses, not always to foreigners, sometimes to all usurers, but here too the entire provision might be dropped. The nature of the automatic sanctions for ecclesiastical transgressors sometimes varied. This too might be dropped. And so too the penalties falling on lay transgressors. There was, in short, no stable core of the decree that was always transmitted across periods and genres, beyond perhaps the basic notion that usury was forbidden, a point that was hardly novel and hardly needed the new authority of a conciliar decree. So even for those who actively sought to familiarize themselves with new conciliar norms, or who were seeking guidance on the church's prevailing penalties for usurers, they might end up with very different understandings of what the church's general law required. Now, at the risk of drawing taboo distinctions between different spheres of normativity, I think it's worth noting the differing consequences of this textual and hence conceptual instability. When 15th century preachers such as Bernardino of Siena ignored the decree's distinction between locals and foreigners, their interpretive looseness obviously shaped the way that their listeners understood the canonical penalties falling on usurers, and perhaps awakened new anxieties in the hearts of local moneylenders who had never imagined that they themselves might be subject to expulsion. But while these preachers thereby shaped prevailing norms, their sermons could not create new positive law. By contrast, when a bishop declared in his statutes that all usurers were to be expelled, he was not merely introducing a new variation into local understandings of the church's general law. He was in fact promulgating a juridically authoritative text that might henceforth take on normative force of its own, complementing or perhaps even competing with its exemplar as a source of local norms. Now, I have not yet followed up every instance of local textual variation to determine whether such changes had real consequences in practice, but it is clear that some of them did. One thing the drafters and revisers did not do, as you might have noticed in reading the decree, was specify whether the decree was to apply to Jewish usurers as well as Christian ones. This is probably because it never occurred to the drafters that it might be used against Jews. For starters, we note from eyewitness accounts of the council the decree was aimed at Lombards, that is, licensed professional moneylenders, usually hailing from northern Italy, hence the restriction to foreigners that came in the first and second revisions of the decree. In addition, while the 13th century church hierarchy certainly denounced Jewish usury, it had not tried to forbid it outright, and all of the earlier canonical penalties falling on manifest usurers had clearly, if implicitly, concerned only Christians. But the language of the promulgated decree was ambiguous, and you can probably already guess where this might lead. 2 months after the close of the Second Council of Lyon, the Bishop of Angers in western France promulgated a new collection of statutes for his diocese, one of which dealt with the topic of usury. The papacy, declared Bishop Nicholas, had banned all individuals and communities from renting or leasing houses to anyone publicly engaging in usury. Since it was clear, continued the bishop, that the Jews of the Diocese of Angers openly engaged in the depravity of usury, all clergy and ecclesiastical institutions within the diocese were henceforth forbidden from renting houses to Jews, or indeed allowing Jews to reside anywhere on their lands. Now, the absence of any reference to foreignness is easily explained by the fact that Bishop Nicholas, like the Bishop of Passau, was working from a draft version of the decree, not the final version. And in that draft, as we've seen, the decree's sanctions did indeed apply to all manifest usurers, not just foreigners. And yet, I think Bishop Nicholas was quite aware that he was putting forth a strained reading of the decree and applying it against Jews. Beyond a few subtle textual changes that point in this direction, the red flag is his omission of the expulsion provision. Good Christian authorities could impose all sorts of unpleasant restrictions on Jews, and indeed church law required them to do so. But expelling them was another matter altogether. Even as papal, canonistic, and theological attitudes toward Jews hardened over the 13th century, the presumption against the expulsion of Jews remained strong. The fact that Bishop Nicholas promulgated the housing ban, but not the full-fledged expulsion provision, therefore suggests that he had a sense that the new decree had not intended to target Jewish usurers, since otherwise it would have overturned nearly 1,000 years of church teaching on the question of their expulsion. Whatever his own personal feelings on the legitimacy of expulsion, he was apparently unwilling, or perhaps unable, to push his reading of the decree to its logical end. So far as we can tell, Bishop Nicholas's statute had little immediate effect. But 15 years later, in 1289, the powerful Count of Anjou, Charles II, expelled Jews, together with Lombards, Corsans, and other foreign usurers, from his northern French domains. The decree of Count Charles not only drew an image of an abyss of usury, usurarum voragine in his text, but was issued, I quote, upon consultation with his reverend bishops and other clerics. And in the roster of names that followed, the name of Bishop Nicholas of Angers figured at the very top of the list. One does not need to look too hard to see Bishop Nicholas's influence at work, prodding the prince to carry out an expulsion from which the bishop himself had once shied away. As you might expect, this would not be the last time that local actors interpreted or rewrote Usurarum Voraginem as applying to Jews, notwithstanding the intentions of its drafters. In the 1320s, for instance, I found various church officials, canon lawyers, and even 2 Italian bishops insisting on such a broad reading. Sometimes only the housing ban was invoked, as in a provincial council of Ravenna that forbade Christians from renting houses to Jews, or the fulminations of the episcopal official of Basel in 1322, who warned a local nobleman against renting houses to either Jews or Corsans, foreign professional Christian usurers. A century later, Bernardino of Siena, seen here, would similarly warn an audience in Padua that it was a mortal sin to rent houses to Jews or Christians for the purposes of usury, citing Usurarum Voraginem as his authority and dropping entirely the decree's restriction to foreigners. In other cases, expulsion was indeed demanded, as in, for instance, the 1325 diocesan statutes of Spoleto in central Italy. Issued by Bishop Bartolomeo Bardi, not perhaps incidentally a sign of the great Florentine banking family, the statutes quoted Usurarum Voraginem at length and went on to specify that its penalties against usurers applied to Jews and Christians alike. For the Jews of Spoleto, Bardi's strictures had little long-term impact. 2 decades later, even though Bardi was still bishop, the city commune welcomed Jewish moneylenders to settle in the city and even offered them explicit protection against episcopal harassment. Many others were not so lucky, but that too is another story. So let me return to what I said earlier about the lack of any stable textual or conceptual core that was always transmitted across genres and across periods. As you all know, particularly from the 13th century onward, the institutional intellectual leadership of the Catholic Church showed persistent concern with the broad dissemination of norms and doctrines. This was motivated by a belief that right behavior and right belief were necessary for salvation, for clergy and laity alike. The efficacy of such efforts was long a matter of debate among both Protestant and Catholic scholars, and particularly between Protestant and Catholic scholars. And yet, there's no doubt that the perceived failures of these efforts were vital to the reforms of the Council of Trent, about which many of you in this audience are considerable experts. But when it comes to legal norms, historians of the medieval church and of late medieval religious life have focused mainly on the structures of dissemination rather than on the substance of what was being disseminated. Theological doctrines have been studied, but far less so legal norms. Legal historians, of course, have been very interested in the theme of reception, normally concerned with formal legal sources as opposed to some of the more informal sources that I mentioned here. And we see an example here in a great article by the French scholar Louis Boisset, in which he looked at French provincial councils and the reception of the decrees of the Second Council of Lyon. And he duly tallied up all the references of the appropriate conciliar decree that were found in the canons of the provincial councils. But of course, all we see from this is whether there is a reference from one decree to another. We don't know what is left out, what is changed, what is transformed, how it's interpreted in these new contexts. And again, thinking about critical apparatuses, and here I'm showing the unfortunately never published but marvelous Habitationsschrift of Peter Johannek, which again underlines all of the texts that are borrowed from other sources of law and then gives the sources in the Apparatus Foncium. The helpful editors, many of whom are Germans, because Germans have a gift for this that I can only envy and admire, produce these wonderful sort of Apparatus Foncium, but never specify what doesn't make it. You know, the convention of an Apparatus Foncium is to record what is included, not what is omitted. And that, of course, is a problem when what is omitted is, in fact, substantively important. Now, we have wonderful studies of legal consciousness in medieval contexts, usually focused on single courts, because relying on court records. And usually, where ecclesiastical norms are concerned, these focus on marriage, because in the Middle Ages, as is still true now, church courts spend a lot of their time hearing cases about the validity or dissolubility of marriages. Now, court records, when they record testimony, are indeed wonderful. They get us very close to understanding what ordinary people might have known about law, though of course mediated and filtered and distorted by scribes and procurators and other officials. But such records are relatively rare, especially the 13th and early 14th century, which is the period that I'm most interested in, because the flood of new canonical norms, the flood of new compilations and codifications and decretals. Hence we must turn to proxies, to synodal statutes, to sermons, to penitential handbooks. And if they don't reveal what ordinary people certainly knew, they at least suggest what they might have been taught by literate authority figures in their communities. And yet we don't know yet what kinds of legal norms disseminated most broadly, or most rapidly, or most thoroughly. The great conciliar collections and papal codifications give an impression of jurisprudential flatness, of perfect equality from text to text. There's no editorializing in Liber Extra. Nothing says, this is the key bit, this is just fluff, or if you only have so much political capital to expend, this clause is what you really should enforce. There are, of course, laws that really only concern legal professionals or highly specialized subsets of a population, certain elements of legal procedure, for instance. But what of all the rest that did ostensibly concern most or all people living with the medieval Christendom? Did norms concerning marriage follow different paths of dissemination than norms concerning Jewish-Christian relations? What about sanctions? Did laws with stringent sanctions get transmitted more or less fully than those with lesser ones? We don't yet have a general model of the differing regional geographies of normative dissemination, or even within regions, a sense of the differing patterns of urban versus rural dissemination. Nor do we even have much of an awareness of chronological differences. Did local normative knowledge of canon law increase over time? Or the people of some communities better informed about certain church norms in 1250 than their descendants 100 years later? These questions can't be answered by looking at formal law books, the codifications, the canonistic commentaries, and so forth. Insofar as they can be answered at all, we must look beyond such texts. Now, I fully admit that the research difficulties are significant. Just to pursue this single decree, I looked at about 1,000 manuscripts, 150 archives and libraries in 16 countries, and I had almost the limitless resources of Harvard's Widener Library and Stanford's interlibrary loan staff. That is not something that is easily replicable almost for anybody else, young scholar or otherwise. Now, admittedly, I was interested in all of Europe across the whole of the late Middle Ages, and one could adopt a geographically or chronologically limited perspective. But people travel, and they carry manuscripts with them, and manuscripts can be opened long after they were made, which to me suggests the dangers of embracing a too-bounded geography or chronology. Now, digital tools, including the handwriting text recognition of manuscripts, will facilitate this sort of work. And already the mass digitization of manuscripts, along with the mere fact that many archives now have email addresses, makes it far easier now to do what I did than when I started 15 years ago. And I've been trying in my own small way to advance this project into the field of medieval episcopal statutes through the Corpus Synodalium project that Benedetta mentioned, which by this fall will have 90% of all statutes issued before 1400 available in full-text searchable editions. And we are now slowly venturing into the 15th century. Now, I recognize, of course, that huge amounts of written material have been lost, to say nothing of what was never written down at all. But that simply reinforces the value of a comparative approach, since relative patterns might compensate for the limitations of absolute ones. If we can't say how much people knew about something, we may nevertheless know they knew more about X than Y. Indeed, my thinking on this project began with a comparative question. When I defended my dissertation and proudly presented the results of my findings on Usurorum Viragonem, an eminent legal historian on my committee asked whether such patterns were typical. And I had no answer because I hadn't looked at anything other than my decree. And fortunately, another eminent legal historian ran to my defense and said that it wasn't my fault that I couldn't answer the question because nobody could answer the question because no one had ever done the research. And maybe that would be a project for me or on armies of me might tackle thereafter. Now, so I have begun this work in a small way, at least within the corpus of episcopal statutes, looking first at the entire medieval legislative corpus concerning usury, concerning the appropriate treatment of Jews, and also the transmission of the Fourth Lateran canon Omnis Utriusque Sexus, the great canon that required annual confession. Now, what's interesting is that for Omnis Utriusque Sexus, it proves remarkably textually stable as it gets disseminated in different genres and different periods, except for the sanction clause against priests who broke the seal of confession. The canon of the Lateran Council specifies lifetime imprisonment for any priest who so behaves. Many of the local reiterations of the canon neglect to mention that fact. With regard to In non nullus provinciis, the 68th canon of the Fourth Lateran Council that mandated distinguishing garb for Jews and Muslims, and also imposed Holy Week restrictions, episcopal statutes that transmit the requirement for distinct attire are more than twice as common as those that transmit the other tenets of that particular decree. And again, they're more than twice as common as statutes that transmit the ban on Jews holding public office, which was also ordered in the 69th canon of the Fourth Lateran Council. And so, as with Usurorum Viragonem, we can see a differential dissemination of elements even within a single conciliar decree, as well as textual variations. And just as the patterns of the local dissemination of Usurorum Viragonem varied markedly from those of its companion decree Quamquam Usurari, both anti-usury canons both issued at the Second Council of Lyon, so too did the various elements of the anti-Jewish legislation of the Fourth Lateran Council have varied dissemination patterns thereafter. Now, I need hardly remind the members of this audience of the danger of writing legal history from codified legal texts alone. Assuming that legal history is concerned in any degree with the knowledge of law, and more precisely, with the knowledge of law among those who didn't spend their lives as professors in Bologna or Montpellier or Orléans, one must look beyond codified legal texts. But I hope that I've managed to show through my case study here today how the same concerns about the effacing of local particularities that have animated so much of the early modern research program are equally applicable in a high and late medieval context. As Martin Bertram recently lamented, scholars of medieval canon law have not shown much interest in the era from 1250 to the Council of Trent, nor until recently have scholars of canon law shown much interest in the period after the Council of Trent either, although happily that has begun to change. This is despite the huge amount of legal literature that was produced during these late medieval centuries, a point already underscored by Roderick von Stinsting more than a century and a half ago. The attention of canonists has focused instead on dissemination of papal decretals up to the early 13th century, on the construction of the great compilations and codifications from Gratian to Liber Extra, and on the glosses and commentaries to these texts. I'm sure that there remains much important work to be done on these venerable topics. But for those who, like me, happen to think that law gets even more interesting once it has left the law books, I think it's fair to say that our work as medievalists is just beginning. And I'm grateful to the many scholars of other periods and places who are showing us what might be possible. Thank you.